So I'm fairly convinced that a good portion of my former friends actually think that I was radicalized by the far right on YouTube. And that's why I left the Democratic Party. Not because I thought for myself, not because I looked at a wide variety of opinions and ideas and came to my own conclusions, but because I went down the alt-right rabbit hole and was radicalized by those evil YouTubers. And I have to tell you, there was a couple of months where I was really wondering the same thing. I was wondering, like, what were my opinions so easily swayed by these people on YouTube? I didn't even watch YouTube really up until a little over, probably about a year ago. I started kind of getting into some channels. My husband obviously has always watched it. He was really into it. He said to me all the time, he's like, you gotta watch Joe Rogan, you gotta watch Ben Shapiro. And I was like, I'm not watching that crap, whatever. But once I did get into it, I really wondered, did people on YouTube sway my opinions? And I'm happy to report that now I know that did not happen. And the reason I know it didn't happen is that the other day I actually found a couple posts that I made about the Hobby Lobby case back in 2014. When Obama was still president and the Supreme Court decided that Hobby Lobby could have a religious exemption from offering certain forms of birth control to its employees. And of course, when this happened, all of my friends were going like, oh my god, no, women's rights are being restricted. Hobby Lobby is an horrible organization. Now, at the time, I was making a lot of jewelry. I was very into making jewelry. I was selling jewelry, and I was doing some shopping at Hobby Lobby. They had very specific things that I liked in regards to jewelry making that were very, very affordable. And so I was a Hobby Lobby fan. And so I really looked into the Hobby Lobby case, and what I discovered was that Hobby Lobby was offering birth control to its employees. Not only were they offering birth control, they were offering something like 16 different options for birth control. They simply weren't offering the ones that were effective after the person was pregnant rather than before. That was what they objected to. But Hobby Lobby employees actually had access to a significant number of choices of birth control. I remember when I got on birth control back in the day, back in college, when I went to Planned Parenthood to get on birth control, I was given 3 options. 3. That's it. Hobby Lobby employees have 16 different options, and the left is going insane saying, oh, women's rights, blah, all this stuff. And so at the time, I posted a couple things on Facebook. This was the first one. I said, I know I'm probably going to lose my women card for this, but the Hobby Lobby decision is not the tragedy that people are making it out to be. I would like my chiropractic care 100% covered by insurance so that my boss can't make the decision of what type of medicine I choose. It is not. Where's my Supreme Court case in outrage? And then I got so much pushback on that one, I followed it up. I am profoundly disturbed by all the misinformation surrounding the Hobby Lobby case. Sometimes there is a dark black line between right and wrong, and when you blatantly ignore facts because they don't fit into the story you're trying to tell, you easily wind up on the wrong side of things. Things like this make me pretty disgusted to associate with the more progressive side of the House. Their brand of extremism is no better than the Tea Parties. That was on July 1st, 2014. I have to admit, I was a little proud of myself. When I saw that in today's context, I was very proud of myself. I pushed back and I said, no, this is my mind. I don't think this Hobby Lobby case is the end of the world. I don't think it's the end of women's rights. I don't think anything of the sort. And I bring this up because today, the Supreme Court decided another birth control case. And again, people are going crazy. They're going nuts. And again, it's really not that big of a deal. This is not that big of a deal. And we're going to talk about why that is. But before we jump to that, folks, if you like the content I'm producing, please consider subscribing to my channel, turning on those notifications, giving this video a thumbs up. If you think you are subscribed, you just go ahead, double check. You know YouTube's gonna YouTube, man. What can I really do? All right, let's talk about today's Supreme Court decision. And guys, I gotta tell you, I spent a lot of time looking for information about today's Supreme Court decision, and I don't know if annoyed would be the correct word for it, but I'm really peeved that no freaking newspaper that I've seen so far has actually gotten this Supreme Court decision correct. But we're gonna look at just the introduction on the Wall Street Journal, and then we're actually gonna look at a legal analysis of today's Supreme Court case. So the Wall Street Journal reports, Supreme Court okays religious and moral exemptions for birth control coverage. court upholds Trump administration rules that expanded moral and religious exemptions. And then it says at the beginning, the Supreme Court on Wednesday upheld Trump administration rules that expanded moral and religious exemptions to a federal requirement that employer-provided health insurance plan cover birth control with no out-of-pocket expenses. And so it's not exactly what it did. It's not exactly what it did. Let's actually go over to the SCOTUS blog analysis. And this is going to get a little thick. It's going to get a little heavy, but I think it's really important to understand these things. It really is, especially if you are on the more liberal side of the House. It can be very easy to get up in arms about these decisions and say, women's rights are over, it's finished, and and act crazy. But you have to actually read the nuance of these decisions. It's really important, especially with Supreme Court decisions. They're deciding on very, very specific parts of the law, and it's important to understand what they are actually deciding on. Whether or not you agree with the decision or you don't agree with the decision, it's important to understand what exactly it is. So this comes from Amy Howe from SCOTUS blog. Court rejects challenge to exemptions from birth control mandate. The Affordable Care Act's birth control mandate requires most employers to provide their female employees with health insurance that includes access to certain forms of contraceptives. In 2017, the Trump administration issued new rules that expanded an exemption from the mandate to allow private employers with religious or moral objections to opt out of providing coverage without any notice. So the biggest question I had today is, what is the very specific criteria for what constitutes a religious or moral objection? Okay, because listen, it's not as though any CEO of, say, like CVS, right? It's not like the CEO of CVS can say, I object on religious grounds. That wouldn't happen. It wouldn't actually apply to them in this case. But if you look at something like the Hobby Lobby case, it even says down here, the federal government excused churches and other houses of worship from having to comply with the mandate. It has also created an opt-out process for religious nonprofits that objected to having to comply. So even in the law already, we've got exceptions for churches and houses of worship, and we've got exceptions for religious nonprofits. What the Hobby Lobby case did is it added onto that by ruling that a corporation owned by a devoutly religious family that objected to having to provide female employees with access to contraceptives could also opt out of the mandate. And part of that ruling was that it was a closely held family organization. That was part of the criteria of the Hobby Lobby ruling. So this expands the exemptions in a different way. But what I want you to notice as we go through this is the court is actually not very clear on what the criteria is for a religious exemption. And this is going to keep coming up over and over again. This did not decide this case, as we're going to see as we continue to go through this analysis. 2 years later, the birth control mandate was back at the court. This time, the challengers were religious nonprofits who argued that the opt-out process created by the Obama administration, which required them to notify HHS of their objection to the mandate, placed a substantial burden on their exercise of their religion. But the Supreme Court, with only 8 members after the death of Antonin Scalia, didn't resolve the dispute. Instead, it sent the case back to lower courts with instructions for the two sides to find a way to respect the nonprofit's religious beliefs, but still allow the female employees to receive full contraceptive coverage. Today's ruling comes in a dispute that arose after the Trump administration issued new rules that extended the exemption from the birth control mandate to cover private employers that have religious or moral objections to providing their female employees with access to health care. So again, we're seeing that this applies to private employers with religious or moral objections. And the question that I still have is how does that actually get quantified? How does it get quantified that a private employer, not a public company, and that's important, a private employer, so it's kind of following that Hobby Lobby guidance, a private employer with religious or moral objections. How is that quantified? This is the question that we're going to keep coming back to. 2 states, Pennsylvania and New Jersey, went to federal court to challenge the expansion, arguing that the new rules violate both the Affordable Care Act and the federal laws governing administrative agencies. I would actually argue, and I'm not a lawyer. I'm not a lawyer at all, but I don't understand how this was an expansion, to be honest. This is pretty clearly what the Hobby Lobby case said. Hobby Lobby is a privately held organization. I don't understand how it expands the exemptions when we're talking about privately held organizations with religious or moral objections. That's exactly what Hobby Lobby is. That's why they won their case. But let's keep going. Let's see, where did I leave off? A federal district court agreed and blocked the government from enforcing the rules anywhere in the United States, and a federal appeals court upheld the ruling. The Trump administration and the Little Sisters of the Poor, which is a Catholic religious group that works with the elderly, asked the Supreme Court to weigh in, and the justices heard oral arguments by telephone in May. So here's where we're getting to the decision. Justice Clarence Thomas wrote for the court in an opinion that began by rejecting the state's arguments that exemptions violate the ACA because the law only authorizes HRSA to identify what preventative health plans must provide, not create exemptions from that care. So the court has rejected the argument that the law does not allow objections in this case. So that's point number 1 in the ruling. The ACA, Thomas observes, gives the HRSA virtually unbridled discretion to decide what counts as preventative care and screenings. That discretion, Thomas continued, is equally unchecked in other areas, including the ability to identify and create exemptions from its own guidelines. So what the court is saying is that, yeah, the government can create exemptions. That's what it's saying. Okay? The government can create exemptions. That's what was basically decided on. Could they not create exemptions? Could they create exemptions? Thomas pushed back against the suggestion made by Justice Ruth Bader Ginsburg in her dissent that the majority's conclusion will make it harder for women to obtain free access to birth control as Congress intended. I don't think that that's true. I mean, listen, you can walk into a Planned Parenthood right now, right this second, grab a free handful of condoms, and walk right out. Condoms are birth control. You can easily get them for free. This does not actually make it harder. Congress, Thomas stressed, should have enacted specific language in the ACA requiring healthcare plans to cover birth control, but it didn't. This is another important point. What Justice Thomas is saying is that Congress didn't make a provision for this. This was not in the ACA. It wasn't in the ACA, and instead, it gave the HRSA broad authority without any qualifications. Therefore, Thomas posited, Congress, rather than HHS and other executive branch departments, should bear the blame for lack of coverage for women. So what this is saying is that birth control was not included in the ACA. This is Congress's fault. Congress is like, this is the big issue that I have with so many of these Supreme Court decisions, and actually a lot of Trump's executive orders too. Listen, all of this could be remedied. These could all be moot points if Congress would just do its job and act like adults. So Congress had the opportunity to include this in the bill, and remember, this was passed right when the Democrats controlled everything. They controlled everything. Why didn't they have it in the bill? If it was so important, why didn't they have it in the bill? It's not in there, and that's why this Supreme Court ruling came down the way it did. Because the rules creating the exemptions were consistent with the ACA, Thomas explained, the court did not need to weigh in on the government's argument that the exemptions were either required or authorized by the Religious Freedom Restoration Act, a 1993 law that bars other federal laws from placing a substantial burden on an individual's free exercise of religion. So I'm going to say that one again because that's another important point. This decision has less to do with religion than it does with the process for creating these bloody exemptions and if the government is allowed to create these exemptions or not. That's actually what's being decided here. It really doesn't have a whole heck of a lot to do, at least from Justice Thomas's perspective, with religious freedom. So I just want to read this again. Thomas explained that the court did not need to weigh in on the government's argument that the exemptions were either required or authorized by the Religious Freedom Restoration Act. Having said that, Thomas continued, it was appropriate for the departments to consider the RFRA because the potential for conflict between the contraceptive mandate and the RFRA is well settled. Indeed, Thomas noted the Supreme Court's earlier decisions involving the mandate all but instructed the departments to consider it going forward. So what he's basically saying is, we've already decided this. The government has to consider this in the implementation of this law. Thomas next dismissed the state's arguments that the exemptions were invalid because the government did not follow the proper procedures when it enacted the rules finalizing the exemption in 2018. Among other things, the states had contended that there was no indication that the departments had maintained an open mind, because the final rules closely resembled the earliest versions of the rules, suggesting the departments had not taken any comments on the interim rules. All that matters, Thomas made clear, is whether the departments followed the criteria outlined in the Administrative Procedure Act, which outlines the process an agency must follow when issuing new rules, and it did. This, again, is a question of procedure. That's what this is. This really doesn't have a whole heck of a lot to do besides looking at the earlier court rulings on the RFRA. This really doesn't have a whole heck of a lot to do with religious freedom. To be honest, this is a procedural issue. Can the department make exemptions or can't they? That's what they decided here. The court today, explained Thomas, held that the government had the statutory authority to craft that exemption as well as the contemporaneously issued moral exemption, and that the rules promulgating these exemptions are free from procedural defects. See, the media likes to blow this all up and makes this a big thing about women's rights. This is about process. Most of the Supreme Court stuff, guys, is boring. It's about process. It's about how it's implemented. That's what's happening with DACA. That's what happened with the Supreme Court decision about DACA. All it said, it didn't say Trump couldn't get rid of DACA. All it said was he had to follow a certain process, and he didn't follow that process before. And now, guess what? Trump is following that process. He's going to do what he wants. Now, I still hope that he makes provisions, or that Congress should really be the ones to do this. They make provisions to protect the Dreamers. I think that they should not be sent back. I think that they should absolutely be welcome to stay in this country. It's the only country they've ever known. But the argument is not whether or not they should be allowed to stay. The argument is whether or not the proper procedure was followed. That's what we're talking about here. Justice Samuel Alito filed a concurring opinion that was joined by Justice Neil Gorsuch. Alito would have gone farther than the Thomas opinion and ruled not only that it was appropriate for the departments to consider the RFRA, but also that the departments were required by the RFRA to create the religious exemption. So he's basically saying, he's kind of saying the same thing that Thomas said in a little bit more stronger language, like, we done already ruled on this. Follow the ruling. We've already ruled on this. You're required to follow the ruling. That's all that's saying, I think. Again, I'm not a lawyer. This is just my layperson's opinion, but I just think it's interesting. And then Justice Elena Kagan, Obama appointed, along with Stephen Breyer, in which she agreed with the result the majority reached, but not with its reasoning. And this is where we know that this is not the end of this particular Supreme Court battle. It's not. Since the Obama administration, she observed, the federal government has interpreted the ACA to give HRSA the power to create exemptions from the birth control mandate. She would defer to that long-standing and reasonable interpretation. So even she's saying, Elena Kagan, Obama appointee, is saying, yeah, they have the ability to make these exemptions. Yes, they have the ability, and we're just going to abide by that. That's the way it is. However, she noted that when the cases return to the lower courts, those courts will have to address the issue that neither they nor the Supreme Court had previously reached. Whether the exemptions are arbitrary and capricious, that is the product of reasoned decision-making. And she suggested the exemptions HRSA and the departments issued give every appearance of coming up short to that standard because they are too broad. For example, Kagan suggested even publicly traded corporations can claim religious exemption as can employers with only moral scruples. And this comes back to the question I had at the very beginning. what qualifies an organization to claim a religious objection. With Hobby Lobby, it's pretty clear. Hobby Lobby's, the family that owns Hobby Lobby is a devoutly religious family. And that actually turns out for good for its employees. Listen, all Hobby Lobbies, when they're open, I don't even know if Hobby Lobbies are back open yet, but when Hobby Lobbies are open, they always have Sundays off. The stores are always closed on Sundays. The reason the stores are closed on Sundays is because the owners want their employees to take the day off to go to church, to spend with their family. They believe in that. That is a positive way in which their religious values are applied. Other ways they're applied is, it's my understanding that Hobby Lobby has always paid its employees above minimum wage. It's my understanding that they provide great benefits for their employees. These all come from the moral convictions of the owners to be able to do that. So the question I have, that's a pretty clear-cut case. The owners of that particular organization have written extensively about their religious beliefs. It's very well known. I can absolutely see carving out a religious exemption for organizations like that. But what this case does not decide, to the best of my understanding, and if I'm wrong, please explain it to me, but I've spent the better part of the last 3 hours looking for this information and I haven't been able to find it. What this ruling does not do is say, here is the specific criteria for the organizations that can claim these religious and moral objections. And it seems like what they're doing is sending it back into the government to give those specifications, to make the case that to essentially make less broad exemptions. Because again, the CEO of like a company like, well, I guess CVS is probably a public company, but the CEO of, I don't know. I don't even know. I can't even think of a private company off the top of my head. But a large private corporation can't just raise their hand after not attending church for their entire lives and say, I claim religious objection to this rule. I don't think that's going to fly. They're going to want more specificity about who specifically can claim these exemptions. Now, with the sisters that brought this lawsuit, they're literally Catholic nuns. I think that they've got a pretty good case to make. But we're going to see how this is applied. But I think the biggest point I want to make with this is that for anyone that's freaking out about this ruling, this is like one of the most boring rulings in the world. It has to do with process and procedure, and that's it. This is not destroying women's rights. If a woman works for an organization that, first off, has strong religious values that are not in line with the employees' values, then why are you working for them in the first place? Honestly, you cannot expect that if you are going to work for an organization whose values are completely misaligned with yours, that's just not a good fit, man. Go get another job. And that's really the bottom line. If your employer doesn't provide you with the type of coverage that you want, go and get another job or go buy supplemental coverage. This is not a big deal. It's not. And when it comes to the religious nature of these objections, I mean, you all know, those of you who have watched me before, I'm not a Christian, but I fundamentally believe that if I want my wacky spiritual beliefs to be protected under the First Amendment, then I have to defend the religious and faith-based beliefs of people whom I disagree with. I disagree. I don't understand why Christians don't endorse birth control. I don't understand why it's against their beliefs, and I don't particularly care to have anyone explain it to me, to be quite honest. My grandmother was excommunicated from her church after having 8 children and living in poverty because she took birth control. She had the gall to take birth control, so I don't really care. I think it's stupid, but that's not the point. These are people's deeply held religious beliefs, and you don't have to agree with them to respect their right to practice them. And all this is saying, essentially, is that the government has the ability to create these exemptions, that if Congress wanted birth control coverage to be included in the ACA, then they should have damn well put it in the bill, and that there's probably going to need to be additional clarification about what constitutes, what types of organizations can claim religious and moral objection. So, this is not an emergency. This is not a crisis, feminists. It's not a crisis. It's going to be fine, because what you should be arguing for is really, really, really specific guidance around what types of organizations can claim these exemptions. That's where you should be focused, and that's what's going to provide the best guidance for all of us. And guess what? Then if someone doesn't want to go and work for one of those types of organizations, they don't have to. They know what the rules are. All right, folks, that's all I've got for this video. Listen, so what I'm going to be spending the rest of my day doing, you can look forward to part 2 of this, is I'm doing it. I'm finishing the dang book. I'm going to do it. I'm going to power through it. So I'm going to post this video, then I'm going to get to reading. I'm sure there'll be lots of tweets and parlays sent out soon. And of course, when I finish White Fragility, you can expect another video from me on the back half of that crazy, insane book.